So good evening, ladies and gentlemen, and it's our great honor to have Dr. Nagasawa coming from Japan to join our program today.
Everybody, dear audience, and dear MeiHsin, thank you for inviting me to here. Okay. I'm very happy to be here. Thank you.
Thank you, Nagasawa-san. Nagasawa-san is the General Counsel for Canon. We know Canon is the world-leading brand with advanced image technology, and it was trusted by professionals, contribute to many different industries. And then, as you can see, this is the very first Canon camera, 70 years technology advancement. And as you can see, this is also the very first camera in Japan. I believe it will also be the very first in Asia too. Nagasawa-san, we know it's your first trip to Taiwan. I was wondering, how do you feel about Taiwan? Yeah. Any particular assignments?
It's very warm, actually. Well, the typhoon was gone now, yeah. And I'm very happy to get a very good flight, comfortable flight, and photographer utilizing Canon's camera. I'm very happy.
Yeah, we just noticed even the director used Canon's camera today to film this recording. So it just again proved the Canon technology is well trusted for a worldwide professional. Nagasawa-san, you are the Canon head of IP, and recently we heard a lot of patent litigation. They were aroused by the patent asserted entities, and I believe it seems the NPE issue is become the most important topic for corporate to manage their IP rights. I just wonder, would you mind to share your view and your idea how to deal with this problem?
Yeah, and the current situation itself, I can explain. Yes, we got 10 to 15 litigation as a defendant. All of the plaintiff were PAEs, no operating company that demonstrate how PAE influence the industry. And basically, I try to follow the general purpose of the patent system, namely, patent system created for investors who invest in researching technologies to get the good business, don't steal their technology, don't steal their business models, and so on. But however, it's coming software is very popular, and network is get higher and higher. The many standards have to be used. Recently, Internet of Things, if it comes, and so many patents are surrounding in business areas, that PAE is try to get the business, that the difference between the law itself and actual business itself. Then a number of the patents increase so much, and some of the company get very bad financial situation. They start selling, they start circulating, then they fit certain patent, even it's good or not. Then they try to monetize that sort of patent against the all operating companies. Therefore, that attitude or that activity is not so comply with the original general patent system purpose. Therefore, I try to make an effort on not so easily settled, not so easily to give them money. But my recent situation, and U.S. and start changing some laws against the PAs, and other countries also somewhat start, against the PAs. For example, it get very little possibility to have an injunction from a PAE. And probably worldwide, even Japan, recently we have a high court decision. It's not PA, I'm sorry, but PA problem, and I think it get more and more, popular and understandable. And I wish it come to the rule or some of the, regulation. PA's, litigation court shouldn't allow the injunction, but I don't want to deny all damage compensation. It's originally made by somebody else. That somebody else have to get small money because of they need to compensate their investment. But injunction causes huge damages, and especially considering the millions of patents. And if we got injunction from one, we need to pay stop injunction, and another one. Many patent holders, many PAs at the moment, Therefore, basically, I would like to, ban the right to, requesting injunction from the PA.
Thank you very much, Nagasawa-san. Except for the PAE, standardization and essential standard pattern are another trendy fashion to be dealt by the corporate. Would you mind enlighten us your view on deal with the standard essential pattern and friends, which is we so-called fair, reasonable, and non-discriminating licensing?
Some professors and some of the lawyers sometimes mixtures and problem of the PAE and SEP stand for standard essential patent. SEP's one is certainly different because at least some of the standard is now in the almost infrastructure or dominating in the networks, and apart without using that sort of patent, standard essential patent, a company located in electricity or software couldn't make any business. Then it's the same as planes, ships, or this sort of public interest or publicly useful infrastructure. That's why that sort of standard essential patent have to do with this sort of infrastructure is not so harmonized with right of injunction. That's why International Standard Organization (ISO) try to ask the patent owner to make a declaration not to utilize injunction right, but we license on a fair and reasonable and undiscriminatory basis. That is a Crown declaration. However, some of the owner not willing to make that sort of declaration. Therefore, I don't want to discriminate and existing with the fund and not. However, legally, the lawyer said fund declaration is a very good base of the stop injunction, but it may be unfair, and if somebody with some merits willfully not to submit the declaration. In that case, if they have injunction right, it's not so fair. Therefore, probably different solution exists. Patent owner who submitted FRAN declaration, so court can rely on the FRAN declaration. However, SEP owner who haven't submitted any FRAN declaration, in that case, they deceive users. That sort of solution may exist. And also, I would like to say some of the patent is basically fully utilized some international standard. The area is also we should consider in the future. Currently, many litigations happen by utilizing standard essential patent, and value of the standard essential patent is now stabilized in a certain amount, sometimes too low, sometimes too high. Currently, I'm very happy to see, and not so many injunctions happen in the world. And also, however, some of the people, especially PA, threaten us, try to utilize some of the standard essential patent or related patent to, threaten us. I will request injunction. But we should separate standard essential patent and PA patent. That's why sometimes people believe PA and SEP problem is a mixture. Well, standard essential patent, I think it's basically infrastructure. That's why it's not so, good, good to, allow owner to request injunction. Well, very shortly.
Okay. Thank you very much for Nagasawa-san very comprehensive analysis. Now, recently, Taiwanese company are suffering from the key officer or technicians were headhunted by the competitors' company. We wonder, as the General Counsel of Canon, when Nagasawa-san will kindly elaborate your management principle how to deal with this sensitive trade secret issue.
When I was young, the people filed the patent, any technologies, because at that time the Japanese people believe the patent is almighty. However, recently we encountered many problems with other companies. Some of the company was stolen their core technologies, and then fall into some difficulty to manage the work, and part of their business was eaten by stolen companies. And for example, Canon have based on the technology of the manufacturing of the product, and manufacturing way in our plant is not so easily shown from the outside. If we can make up the full specification about our technology in the manufacturing, in that case it's much easier to demonstrate to you. And therefore, so trade secret, especially technical trade secret, get more and more important than before. We should sometimes utilize trade secret not to be filed, sometimes partially filed. This sort of tactics is very important. And plus, recently, because of development of IT, they utilize IT to hack many technical information. The many information, and even in Canon, is based on software recently. Therefore, and that sort of software modules on source code of software was stolen. It comes to the serious problem. Therefore, our patent itself was still very useful to compete with our competitors. And competitors is many companies like even IT company, even vehicle company, housing company. They commonly utilize in the IT system or networks. In that case, business is not overlapped and patent or IP is overlapped. Then which part of our core technology have to be understood as a trade secret, and what sort of our technology have to be filed as a patent and get the patent right, and it's very important decision in the company recently. It's my feeling. Then Japanese government start to strengthen the trade secret right, and Korea, China, all of the Asian countries start strengthening and certain law protecting trade secret. In Japan, we define or devise an anti-competitive law recently.
Recently, because we have a high-ranking officer who were headhunted from TSMC to Samsung, so we immediately changed our trade secret law. So now we have very high punishment for the violate trade secret law, and also have criminal punishment for the people who violate the law. I just wonder, in Japan, is there any criminal punishment for people who steal or violate the law?
Yeah, anti-competition law is mainly how to do with the criminal sanctions.
Okay.
But problem in Japan was the police is not so familiar about trade secret. Therefore, sometimes they don't think about that seriousness. But booming this sort of problems, especially last year we got Toshiba's affairs and also Shinnitetsu. Then even police officers must slightly get understanding the seriousness of the trade secret, and we change the law, more heavy, fine, more heavy, sanction of the under the criminal law, and plus we change the civil law as well, and that civil law causes defendant who might need to demonstrate or prove they are not using trade secret, and then we can, if we are plaintiff, and we can demonstrate our information there, so they very looks like they are using our technology. In that case, Japanese law said, defendant may need to prove and may need to give them evidence or document. That is a big change, and plus, that sort of trade secret was stolen by ex company's employee sometimes, then that sanction get heavier.
Higher.
Yeah, then I hope that causes some, preventing
people
being
continue
sold,
stealing company
Hopefully.
technology to the new company.
Yeah.
Nagasawa-san, we happen to have this camera. It was also manufactured by Canon. Would you mind to explain the technology upon this camera in front of us?
Right, and we can classify our technology into the two parts. The main part is our core technologies, like optics, lens, and that lens, and you utilize a very expensive one. It's a very good one, and therefore a very bright image can be taken by that lens. Then preventing noise and reflection and blue eyes and these sort of things. To do so, we have a very special manufacturing technologies. A part of it should be a trade secret, and part of it have to be patented. And just the basic concept of the structure of the lens, for example, that lens probably composed of the 15 or more small lenses. That lens is combined. How to combine, how to zoom in, I think it's a basic concept. It should be patented. However, how to manufacture, how long does it take to manufacture, how long you get, coating, and that sort of small taste would be a trade secret. Very difficult to be, steered. But the number of the patent is mainly located in the standard essential patent and surrounding software patent, image processing. Now, for example, the camera, I think, and they need to, send the image to the outside, utilizing, wireless technologies. It's standardized. And plus, if you need to communicate with smartphone, it's also necessary. If you need to communicate to the PC, it's also available. And also, if you can try to print directly to the printers, and they utilize Wi-Fi technologies. Those technologies covered by the standard essential patent and surrounding patents. So many patents existed. Therefore, that camera, I think, at least 10,000 patents is utilized. Of course, we filed many patents on that camera. And also, we have several trade secrets how to do with our core technology.
So Nagasawa-san was very kind to elaborate the camera in front of us through the trade secret to the patent system and how the patent profiling could integrate with accelerated instrument, for example, wireless computers, printing things. And thank you very much for these very comprehensive examples.
Yeah, the camera is named EOS. Some of the EOS is made in Taiwan.
Oh, thank you very much. Nagasawa-san just highlight how Japanese company they deal with and Japanese law deal with the trade secrets. Recently, we heard you were appointed as the AIPPI Japanese group president. And the AIPPI is a political neutral, non-profit, world-leading international organization dedicated to develop improvement regime for protection of IP, not only internationally but also domestically. We heard it's over 100 countries have more than 9,000 members. And I would just wonder, would you mind share your view being the president of AIPPI Japan? What are you trying to do during your presidency?
Yes, and AIPPI Japan, so many members, lawyers or patent attorneys, and of course, Japan is a very specific, group. We have over 150 or 60, operating companies and officers like me. And it's very peculiar in the world in the AIPPI. The total number of the membership come to the over 1,000. It's more than 50% of the worldwide. And once I get the president, so before me, not so practical head of the AIPPI, not coming from industry, but mainly lawyers. And lawyers, of course, they study very hard, they get qualified, and attorney as well. But sometimes they discuss about the law, and that goes to the very small issues. And But lawyers' work and attorneys' work have to do with some of the link to the economy itself. Otherwise, they lose a job, I believe. I try to manage an industry's opinion, lawyers' opinion, attorneys' opinion, that triangle situation. So far, not so strong opinion from the industry. I would like to make some balance. Of course, law is important in the globally. We need to harmonize some of the law in other countries. However, why does law have to be harmonized? It's probably come from some industrial problem. Patent law itself, I believe, purpose is promoting industry or technologies. So I try to get back that purpose, and then I try to put in the importance on the subject largely have to do with the industry or promoting the technology.
Thank you very much, Nagasawa-san. Before we close this section, I just wonder, do you have any word of advice for Taiwanese company or the CEO, presidents of a company in Taiwan?
Taiwan. The same as Taiwan and Japan and Taiwan, I think we have a common strong points. Now we made up a very good camera. Our camera is manufactured in Taiwan.
Yes.
Very well. And that demonstrates, especially Eastern Asia, we have some skill on making certain very sophisticated products. We should keep that core competence for the world. But the difficulty is recently network is get quicker and quicker, and you can utilize cloud and big data, and everything is connected to the internet. In that case, not only the appliance and device can work as a core competence, we should manage our strong point, plus some networks, and we have a suppliers, we should have a user, and it go to the B2B area. Everything is so connected by the network. And the question is, who can get more money? And I believe, if we develop our technology, something like this, it's come from a huge investment. We should keep that strengthen. And to do so, we should see our partner, a network partner, which also have a certain patent surrounding these appliances. And hopefully, we can get some, right to control total B2B business. It's the same as a Taiwanese company. Therefore, hope Taiwanese company make some effort to get the patent of the surroundings. Your strong point.
Okay. Thank you very much for Nagasawa-san's very insightful instructions, advices. Recently, we published a book called Law, Politics, and Revenue Extraction and Intellectual Property by Kenichi Nagasawa Publishing. The editors including the former Chief Judge from CFC Raider, and also the former Chief Judge from Japanese AIPPI High Court, Professor Imura, and also the judges from Germany Federal Patent Court. This book examines numerous pressing issues on intellectual property rights, covering the topics including what Nagasawa-san just mentioned, and the analysis are complemented by in-depth case study, demonstrate with how company can benefit enormously from the integrated application of all kinds of IP rights. We currently plan the second book, and Nagasawa was very kind to be our editors for our second book. And the book will be essential reading for anyone who involved in interest in IP, and also appeal to those business world concerned with managing IP and confronting competition with smart strategies. We hope soon we will have the opportunity again to invite Nagasawa-san back to our program. Thank you, Nagasawa-san.
Thank you.
Thank you. And thank you for the gift. It's very beautiful. Thank you.